Other than our Chief Judge of the Department of Shariah Judiciary Malaysia, Yang Amat Arif Datuk Setia Dr. Haji Muhammad Naim Haji Mohtar, who will be discussing with us and sharing his views on tonight's topic, which is the first of our Sharia law series coming up on pronouncements of divorce in Islam. Yang Amat Arif, recently there was an article in Astro Avani. It was about divorce pronouncement or Lafaz Cerai during PKP. So if a husband were to pronounce talak during PKP and there is no avenue to go to court because the courts are closed, can you please tell us what are the steps available for the wife as well as for the husband to protect their interests and their rights, especially where the couple do not wish to rujuk?
Bismillahirrahmanirrahim. Alhamdulillahi wa bihi nasta'in wa salatu wassalam ala rasulillah wa ala alihi wa sahbihi ajma'in. First of all, let me thank Association of Women Lawyers for their kind invitation to for me to appear and address the members of AWL and also the members public who joined this evening's program. Thank you so much. I wish AWL all the best, and I hope our tonight's or this evening's program will be beneficial to the members and also the members of the public who join the program. Liza, thank you so much for your first question. Before I proceed to answer your question, let me explain the nature what Quran teaches, especially the husband when it comes to divorce. The word used in the Quran is at-talaq. So at-talaq, divorce. Okay. So there are three words which are mentioned in the Holy Quran. The first, Allah SWT says at-talaqu marratani. Talaq is of two times. Fa imsakum bi ma'rufin aw tasrihum bi ihsan. The ayah used the terminology of ma'ruf, which means good. So if a husband wants to divorce the wife, then he has to divorce her handsomely, in a good manner. So in other words, there must be strong reason for him to divorce her. That is the meaning of ma'ruf, Liza? The second terminology used in the Quran, aw tasrihum bi ihsan. The term used is bi ihsan. So we have one ma'ruf and the other one is ihsan. Ihsan means which is beyond ma'ruf, okay? Beyond goodness done by the husband. Which means that if the husband wants to divorce the wife, then he must ensure all the rights, ancillary rights of the wife who has already been divorced must be given. For example, he has to ensure that the wife will get sufficient maintenance known as nafkah. She will also get what is known as conciliatory gift, muta'ah. She will also get the custody of the children, and she will also get the maintenance of the children. So in other words, when a divorce which is known as ihsan, that means the husband must make sure that all the ancillary rights of the children and also the divorcee are protected. That is known as tasrihum bi ihsan. And there is also another verse from the Holy Quran, Aisyah, where Allah SWT says sarahan jamila. So the word Allah used in that Quran is jamila. Jamila means beautiful. Beautiful means if the husband wants to divorce the wife, not only it has to be ma'ruf, not only it has to be ihsan. In other words, he has to ensure that all the rights of the wife will be protected and be given by the husband. Jamila is another step towards more, is beyond tasrihum bi ihsan, which means that whatever the husband give to the wife or the wife who he has already divorced, he must make sure that there is no evil intention behind it. There is no evil intention. In other words, if he wants to give nafkah to the wife as a result of the divorce, there should not be any enmity, permusuhan. There should not be any macam mengungkit-ungkit. Okay, this is what acrimonious. So, Liza, from the perspective of Islam, when we talk about divorce by the husband, then all the husband in Islam must make sure that the divorce must be of ma'ruf. It must be by way of ihsan. And thirdly, it must comply with what is known as sarahan jamila. If all these category terminologies mentioned by Allah in the Holy Quran is respected by all the husbands whenever that he wants to divorce the wife, then this is what is known as an amicable divorce. And this is what the law, Islamic family law enactment, tries to ensure. So in other words, there is a topic, Liza, in the enactment, Islamic family law enactment. My belief, the philosophy is that the three intended objective of divorce in the Holy Quran must be reflected whenever that we want to enact a law pertaining to divorce. I'm looking from the two perspectives, Liza. One is the perspective of the husband. So in other words, if a good husband, whenever a Muslim husband, whenever that he wants to divorce the wife, he has to make sure that these three Quranic injunctions must be respected. It must be of the nature of ma'ruf, it must be a nature of ihsan, and must also be in the nature of sarahan jamila. Okay, so these are the three things that the Muslim husband needs to respect whenever we speak about divorce or dissolution of marriage in Islam. And this must also be the philosophy behind the enactment of any enactment. When we talk about enactment, Islamic family law enactment, my understanding, it must fulfill the Quranic spirit of ma'ruf, ihsan, and also jamila. Okay, Liza, I forgot your question, but
Sorry, Arif, our question was, what can a wife do?
Yeah.
So let's say the husband has pronounced divorce during PKP, they are at home, so both of them cannot go to court and get any kind of declaration. What sort of steps can a wife take, to protect herself? So maybe, for example, should she write down what he said, keep records? What sort of steps would you recommend that she take?
When we talk about court, whether Sharia or civil court, then we'll be talking more about the evidence, right? So when there is an allegation by one party to another, for example, in this particular case, during the PKP, for example, if the husband pronounces talaq, and because of the pronouncement of the talaq, the wife is so worried that what should be the status of the talaq, because she doesn't know. So there is an allegation by one party, which is the wife, against the husband. So what she needs to do is, of course, the evidence. You have rightly pointed out. If any evidence that the wife can tender in court, if she decides to file the declaration of talaq by the husband outside and without court's permission, then she must be prepared with the evidence. So all this evidence must be recorded. Why? Because the independent third party, who is the adjudicator, whenever the case is filed in the Sharia court, the judge would normally ask the party to produce evidence. That lies the importance of evidence when we talk about pronouncement of the talaq by the husband during the PKP. I think that's the most important thing for the wife to do if she decides to inform the court, okay, that the husband has already pronounced talaq. But let me tell you, Liza, in Islamic family enactment, because of the philosophy that I mentioned just now, that the talaq, the divorce must be a handsome one, ma'ruf, okay? The law requires any party, if the husband or wife, if they want to divorce, then both parties is given the right to file an application in court. So in other words, the court will assess whether there is a strong justification for the dissolution of the marriage before the court allows the husband to pronounce talaq. So the question that you posed to me relates to a situation, a provision where it allows for the husband and the wife to inform the court that the talaq has actually affected outside and without court's permission. But I'm telling you what according to the law, the Islamic Family Law Act or Islamic Family Law enactment in other states, it requires the husband and wife to petition or to file an application for the court to grant leave or beri kebenaran kepada suami tadi untuk melafazkan talaq. So in other words, if it is to be a proper talaq, then it has to be filed by both parties in court. But what I can understand,
just to clarify, the husband utters talak dekat rumah masa PKP, and then they file some in court, and does she utter it again in court?
Okay, no, Liza, we have two different sections, okay?
Yeah.
One is section 47. Section 47 of the enactment, it talks about, it occurs when the husband has not pronounced the talak. The husband has not
So
pronounced
they
the
go to
talak.
court and lafaz depan hakim.
Right. So this is what I say. The court will assess the reason behind the application for the talak. If the court feels that the parties can be reconciled, then the court will refer the party to the reconciliatory committee. So in other words, the husband has not uttered the talak yet under section 47.
Right.
Another situation, Liza, what will happen during the PKP, the husband uttered the word talak, whether in the presence of the wife or in the presence of witness or in the absence of witness, the husband has uttered the word talak. So the word talak has already been uttered by the husband without the court's permission. This one, section 57 will apply. Section 57 provides if the husband has uttered talak outside and without court's permission, the law requires the husband within 7 days, he is obligated by the law under section 57 to inform the court. When he presented or when he informed under section 57, then the court will not require him to pronounce another talak. No. What the court will do is the court will see, or the court will hear evidence by the wife and the husband. The court will try to assess what sort of utterance of talak by the husband. So if court satisfied that the word uttered by the husband is a clear-cut talak, then the court will validate it. So the court will validate it at the time when the husband pronounced it, Liza. So that is section 57. So two different sections. One is the husband has not pronounced it, which is under section 47, where both parties require the court to grant the permission for the husband to pronounce talak. And another section, the husband has already pronounced it in their own respective places during the PKP, and then they file under section 57 for the court to validate the utterance of the talak.
Yeah, Arif, what happens if when the court opens and the husband does not go and file? What can the wife do in that situation?
Lisa, the law section 57 states that it is incumbent upon the husband to, within 7 days of the pronouncement, that he needs to file or lodge the complaint or inform the court within 7 days of utterance. So he's under obligation. So if he fails to inform, Lisa, so it becomes an offense.
I see.
Okay, it is administrative offense because the law requires him to inform the court within 7 days. After 7 days, then the wife cannot wait. She shouldn't wait, Aliza, Aisha. She shouldn't wait. So within 7 days, it is the obligatory of the husband, but under section 57. After 7 days, then the wife can file an application and ask the court to ascertain whether the talak has actually occurred or not.
Okay, thank you, Yang Arif. Thank you, Liza. Thank you for your great reminder about the great responsibility of husbands before they utter the talak. I think I have to backtrack a little bit when we're talking about when Liza was referring earlier on about Lafaz Cerai during PKP, okay? And we have a question here. We're not sure whether Sharia courts are actually still operating on PKP. And you mentioned about keeping evidence. What if the evidence was about on SMS and WhatsApp? Okay, there's a question about that. And then what happens until there comes a time when the husband can effectively file under section 47 or the wife continues after 7 days? What happens during that time after the alleged talak? They happen to have to sleep together, or maybe even was compelled. Sexual intercourse was compelled. Okay, does this amount to rujuk, or do you need consent for rujuk?
Okay. Okay, Syam. Thank you so much for your question. Your question relates to two different kinds of talak. I mean, for the benefit, I've seen that we have our non-Muslims brothers and sisters and friends here. When we talk about talak, there are two types of talak. One which is explicit. In fiqh terminology, it means sarih. Sarih or clear, explicit utterance of the word talak, cerai. Aisha, when these words are pronounced, uttered clearly by the husband, the talaq or the divorce will become effective by mere utterance by the husband. This is what we call talaq sarih. It does not require the intention of the husband. So two set of pillars or conditions have already been fulfilled. One is the use of the word cerai or talaq. Secondly, it is expressed lafzan, talafuz. Okay, so it does not require the intention of the husband. Another type of talaq, which is known as talaq which is implicit. Okay, and the second type of talaq, which is implicit, it requires the intention of the husband. This one, Aisha, it includes like SMS. It also includes by way of email. It includes other forms of mechanics used by the husband. Okay, even though the words used in the SMS is talaq, for example, but there is no utterance by the husband, so it's still under the second category, which is not sarih. So what happened is, if the wife during the PKP, Aisha, she received SMS from the husband within the 7 days of receiving the SMS, the husband did not report or inform or file the case in Sharia court. Then after 7 days, she decided to file it. Okay, she would tender the SMS, email as the evidence. This is what, Liza, we spoke about evidence just now. So she would tender the SMS as the evidence by the wife. So now, since the status of the divorce by way of SMS is of the second category, okay, which is not sarih, which I explained that requires the intention of the husband, then the court will ask the husband to come, because once the wife filed the application, same like in the civil court, the summons would then be served on the husband. The husband as a defendant will come to court, and when he appears before the judge, then the judge will ask her whether the judge will tender the SMS as the evidence. The court will ask the husband, is this your SMS that you sent? Okay, then he said yes. Okay, then the second question that the court will ask him is, did you actually intend to divorce or talak the wife at the time you send the SMS? So he said, no, I had no intention. Then the court would not affect or validate the divorce, because it falls under the second category. Back to your question, Aisha, on revocation. And again, for the benefit of our non-Muslim friends, revocation in Arabic known as rujuk. Revocation of the divorce means the husband and the wife will return as husband and wife without the new akad or the solemnization of the marriage. That will happen during the 3 months and 10 days after the husband has pronounced it. This is what we call talaq raja'i. It can be the first talaq, it can be the second one. Okay, at-talaqu marratani. So within 100 days, if the husband and the wife decide to revoke the divorce under the Islamic law, they do not require fresh akad. What the husband will do, if the wife agrees, then the husband will pronounce the word rujuk. So in other words, saya rujuk kembali kepada kamu. So they will come, they can cohabit after the husband has already pronounced rujuk. That revocation will happen by pronouncement of the husband. Now, what Aisha asked me is, can revocation of the divorce take place by sexual intercourse? What more by the husband compelling the wife who have the sexual intercourse? Okay, under the Shafi'i, Aisha, under the Shafi'i ruling, rujuk or revocation of divorce must take place by way of actual utterance by the husband. So in other words, there must be clear pronouncement by the husband that he intended or he intends to rujuk the wife. In order to strengthen that one, Aisha, the law says, okay, under section 47, the law clearly says that if the husband, without the knowledge of the wife doesn't know that the husband has already pronounced talaq, but the husband decides to rujuk her by having sexual intercourse, and she wasn't aware of that. So the law says, okay, what the law says, it is regarded as an offense for the husband to have sexual intercourse without first informing the wife that she has actually been divorced by the husband. So the law requires okay, on the basis of justice, the law requires the husband to inform the wife. But back to the philosophy that I mentioned to all of you, and I hope that if there are husbands I'm not sure how many husbands are here, okay, that's why I explained from the very beginning the philosophy of divorce in Islam. It must be done by way of ma'ruf. Ma'ruf means you cannot divorce the wife without she knows. Okay, that's not ma'ruf. A ma'ruf, a good and handsome a wife is handsomely and in a good situation being divorced if she knows that she is being divorced by the husband. If she's not aware that she has actually been divorced by the husband, then that is not considered as ma'ruf. What more, it will definitely doesn't fall on the second category, which is ihsan, and definitely it is not jamila. So I think I'm taking this opportunity, if there are many husbands here, myself and all that these are the things that we need to practice if really follow the teachings of Islam, and these are the things that we need to know and we need to do whenever that we decide to divorce our own wife. Okay, Aisyah?
Ya, memanglah sebab dah kahwin cantik-cantik, baik-baik, suka sangat, nak divorce tu, nak cerai tu memanglah kena buat betul-betul. That's basically the end of the day. Sorry, Yang Amat Arif, one practical question. People